Securities and financial planning offered through LPL Financial, a registered investment advisor. Member FINRA SIPC. The opinions voiced in this show are for general information only and are not intended to provide specific advice or recommendations for any individual. To determine which investments may be appropriate for you, consult with your attorney, accountant, and financial advisor or tax advisor prior to investing.
Welcome to Planning for Win Financial Guidance in Life. I'm Kevin Pinkley. Thank you for joining us today. Ernie Martin's in the studio with us today. Thank you for joining us, Ernie. How are you?
Thanks for having me, Kevin. I'm doing well.
Thank you. Well, today we were going to talk about asset division during divorce. 50-50 isn't always equal. And as always, if you want to get in touch with me, you can reach me at 832-375-0900. And Ernie, for the listeners to contact you, how would they go about that?
I'm with a law firm, Currier and Martin, Currier and Martin. I can be found at www.couriermartin.com. You can also reach me by email at emartin@couriermartin.com. And then you can reach me by phone at 281-890-7090, extension 103.
Thank you, Ernie. So the title, as we said, Division of Assets During Divorce, 50-50 isn't always equal. And I guess you could loosely relate this to maybe settling estates and some other examples, but primarily it works when we're talking about dividing assets during divorce. Because a lot of times we hear, correct, Ernie, that we don't need to talk a lot about this account or this estate. We're just going to divide the assets and we're just going to take this account and divide it, correct?
Sometimes.
Yeah, sometimes. And when we're talking about it in this example, I'm going to use the example we're talking about a brokerage account. So it's not a retirement account. So that brings a few other concerns in there. To some degree, we could use the example as a retirement account as well. But often we hear, hey, we don't need to spend a lot of time on this. We're just going to take this account and divide it 50-50, either percentage-wise or dollar-wise, and everybody takes half of the account, or maybe somebody has a different understanding of what 50-50 is, and someone is going to choose their 50 and let the other person have the remaining 50. So there's different variations of that, correct?
That's correct.
Right.
And that's where we run into a bit of a morass in our business. Oftentimes, things are very easy to value as far as, you might have a house. You can have a range of values, but they're usually fairly close, that type of thing. You might have a 401k account, which is, my understanding, is basically a complete package. It's going to be worth X number of dollars, depending on what day it is. And if you were to divide that account, we would do a qualified domestic relations order. The plan administrator, after the divorce, would then divide that account, however we tell them, either in a dollar amount or in a percentage amount. Where we run into trouble as attorneys, because most of us are not financial professionals, is when we have a complex brokerage account. And that complex brokerage account might be stuffed full of all kinds of investments. So we might have an overall statement that says this brokerage account is worth $500,000. But that's basically where we start to fall apart. If I want to get my client 50% of that $500,000, and I just simply say 50-50, does the broker know how to get my client that 50%? What if the other party says, okay, we can do this 50-50. I'm going to take this investment A, I'm going to take this investment B, I'm going to take this investment C. The other party can have D, E, and F. Well, that might equate to something different than 50-50 by a lot. In other words, we have dogs. I don't know what you call the good ones.
Dogs is a good example.
Dogs is a good one for the bad one.
Yeah.
The golden goose might be a good name for the good stuff. But the bottom line is not all investments are created equal.
Right.
So in complex brokerage accounts, oftentimes is a matter of diversification, balancing acts, whatever the broker is trying to do. There might be some dogs mixed in with the golden geese. There might be some just really, the safe bet blue chip stocks that pay more of a dividend. The idea, though, is, and this is, again, more of a financial professional's expertise area than an attorney's, is what should my client be looking for? How should my client be aware and know that this needs further analysis by somebody other than just the lawyer?
I'm making furious notes here and kind of chomping at the bit because you've talked about a lot of important things. So,
please dive in. Get us straight.
First thing I wanted to mention is that you mentioned the term brokerage. So there's probably someone the couple's been working with. They could have been spent a lot of time working with the husband and the wife. Sometimes we see that they've only been working with one person, and it's not always gender specific, but hopefully there's a relationship there. Sometimes there's not. But if there's a relationship there, and it's unfortunate that this happens, but the advisor or the broker kind of sees which way the wind is blowing and realizes that this couple's getting a divorce. And what tends to happen is, without announcing it in so many words, the broker or advisor has picked a side. All right? So in the background, there's conversations that have already been held. So we'll pick on the husbands in this example.
Always a fair target.
Okay. And so the husband has mentioned it to his broker that, look, I'm getting a divorce. Maybe it was something I chose. Maybe it's something I didn't choose. But it's going to happen anyway, and we're going to have to divide these accounts up in some way. Now, the conversation goes something like this. I'm going to leave the assets here with you, Bob or Sue. Why don't we come up with a way to divide this account 50-50, where my 50 treats me a little better than it will treat my spouse?
One person's 50 doesn't bark is what you're saying.
Right. And those conversations are being held. Not always, so that's good. But my experience has been it happens quite a bit. So there's already been a conversation, and they're looking at how can this be divided that benefits one versus the other. Because the rough numbers are that when a couple divorces, it's about 75 to 80% chance that one of those spouses or account owners is going to move the account to somewhere else. So if the advisor is in a situation where they haven't even spoke to the other spouse yet, not aware of the divorce, but the other spouse comes into the office and says, hey, this is going to happen. By the way, I'm going to leave my assets with you. How can we come up with something that makes sense? So there's been a long conversation of here's what you should keep, here's why, here's what you shouldn't. And that's not the correct way to do it, but I think it happens more than we think it does. So we need to understand that. Somebody's already made a plan and they have help. Okay, they have inside help, if you will.
Say it's not true.
Yes, it is. It's happening right now as we speak, I assure you. So we need to realize that the advice that you may be getting from your advisor, regardless of the relationship you have or not, may not be the correct advice. So that's why in a lot of cases where, regardless of the type of divorce that a couple gets, whether it's a mediated case, a collaborative case, if they're going to trial, in a lot of cases it's good for both parties to have someone, a financial person, represent their interest and eyeball and take a look at what is there and what makes sense. In the collaborative divorce case, there's a neutral that's working for both parties, so that's good. So you have to have someone look at it other than yourself or the person maybe that you think is on your team being the advisor that you're working with.
Let me interject some here, Kevin, and I feel kind of silly asking you what the law is in this area, but to be perfectly honest with you, I don't know what a broker's ethical code is. So if we have a brokerage account and it lists joint owners, husband and wife, and that broker, again, as you alluded to, is more or less used to dealing with, say the husband, and the husband's the one who's managing it and so forth. The guy doesn't even know the wife, but nevertheless, she is an account owner. What is that broker's obligation? Do you know what their legal obligation is to both parties?
Well, it's kind of a gray area, and the legal side would say it's not a gray area, but there's a term, fiduciary duty. Okay, so they have a fiduciary duty to the client. Now, I think if you ask 6 people what's someone's fiduciary duty in the real world, you're going to get 4 or 5 different answers. So I think the incorrect way that it happens, well, let me back up. The correct way is you're supposed to explain the situation to both parties, exactly what's going on, how things work, the advantages of dividing assets, the pros and the cons, and you're supposed to represent both parties equally. I think in practice that's rare in some cases, especially during a divorce.
And just so the listeners know, in the legal industry, that it would be expressly forbidden.
Right.
There's ethical violations there written down in books that lawyers can look up and understand. And I don't think that brokers have that same ethical code, do they?
Well, they do. But look, there's a lot of great firms out there, and there's a lot of great advisors. I don't know the firm you're working with or the advisor you're working with. More importantly, the advisor, okay, because that's where the advice is coming from. I'm just saying, looking back over the last 20 years, when working with couples or an individual, a lot of times that the information that they're getting or not getting is biased.
So one of the takeaways from our conversation so far is that both parties obviously, say it's a contested divorce, both parties obviously usually have their own legal representation.
Correct.
And perhaps in this divorce setting, a contested divorce setting, both parties need to have their own financial representation as well.
Right. I think that makes sense. So then let's go a little further. You had mentioned dogs of investments. Okay, so that's a good way to say it. Quality is another way to say that. And then when we're looking at the individual advisors, expertise varies. Okay, so they may have both clients' best interest in heart and working as best they can to their ability that to cooperate and represent both people and give them the pros and cons of dividing those assets. But I think, again, looking at the last 20 years of my experience and yours, is a lot of those advisors don't work on the divorce side of assets and dividing assets. And so in some ways, the conversation may be new, okay? And when we talked about the type of advisors, maybe they're not all this sounds odd, but maybe they're not all familiar with what the client owns. Okay.
That's a very likely scenario.
Okay. So, so there's a lot of things to consider, and I'm not saying the person you're working with is the wrong person by any means, but looking back over a few decades, there's a high percentage there that something could be missed for whatever reason, or not explained correctly for whatever reason. And since it's such an important decision, I think having another set of eyes looking at it that are unbiased, or in some cases representing both the husband and the wife. So, and then I'm going to say something else that may shock some listeners, but it's not going to shock Ernie. Your spouse may not have your best interest in mind, okay?
I'm appalled.
So, and what I've seen is usually the longer the marriage, the more deception that might be there with the longer the marriage. So the example is, there's a 20-year, 30-year, 40-year, 50-year marriage. That, I don't know why, but maybe for some reason there's more of an incentive there to not have the other person informed about making decisions. And it's terrible, but it happens. And I'm not speaking for Ernie, but my experience is the longer the marriage, the more chances of that scenario taking place. I don't know why. It just seems to happen. And at first I was surprised, but now I'm not. And I'm sure you've seen a lot more divorce cases than I have, but I mean, those things tend to happen. So,
Oh, yes.
yeah.
Yes.
And so continuing this talk about quality, the dogs, the good investments, the not so good investments, within that brokerage account, the quality of those investments vary. So if you want to think about it, they're kind of like trees. Trees do different things, okay? Some trees grow very fast and stay green all year long. Some trees take forever to grow, but they drop acorns. They provide a lot of shade. So that's a simple way of looking at the investments. But the investments that are in there are different animals. And usually when we look at people's accounts, there's different thoughts there. And each investment has a different job. So when we start dividing it up, I like to say, let's find out what's there, why it's there, and how it works. Because not everything there is the same. And it doesn't matter which firm you're with, there can be quality investments, but the investments work very differently. So not all the investments are the same, and we just need to have a better understanding of why they're there, how they work, and what they do. And in some cases, a refresher, okay? Because it's not something that we look at on a day-to-day basis and look at, well, if I had to divide this joint account, which one would I take on Tuesday versus, 2 years from now? So it's good to have that look. And
I assume from this, going back to our recent conversation on collaborative law, where we talked about collaborative cases being a little bit different than litigated cases, and one of the reasons why is interest-based negotiations, where we're taking the temperature of the clients to find out what are their long-term goals and interests. And, again, that in divorce cases, that can apply to how the children are raised, co-parenting, all kinds of aspects. But when we're talking about a brokerage account, various investments might have different aspects from the standpoint of, this is a long-termer. This is one that you buy into and you don't look at it again for another 20, 30 years.
right.
Versus this one's going to be high risk, and this one needs constant looking after. And then there's the middle of the road investments. And again, so I suppose how a brokerage account would be divided, what investments a particular party might want, depends on their long-term goals and their plans.
Right. And in a lot of cases in divorce, maybe their plans or goals are the same. Maybe they've been modified, or maybe they should be modified. And in some cases, they've completely changed. So in some cases, the investments there may make sense to keep. Maybe there's suggestions to modify them a little bit. And you mentioned short-term, long-term, what I would call intermediate. Okay, well, some of those, with the structure of the design of those investments, are longer-term, short-term, and intermediate. And some of them have issues where they may be long-term investments because there's no liquidity there, meaning we can't sell, exchange, or move out of that investment. In some cases for a very long time. So maybe that investment made sense when it was added, but then we look at it and say, you have committed, whether you are aware of this or not, that you have to own that investment an additional 5 years. Okay, well, that would be nice to know. Now, that asset could be divided, and it now is in two different statements, one for each spouse. And then 2 years from now, you go, well, I'd like to change this investment. I need some liquidity or whatever. And then you find out that you can't sell that investment in any way whatsoever, or move it to another investment because you've made a 5-year commitment. The longest commitment that I've seen on paper that the client wasn't aware of is they had committed to 17 years to hold this investment. 17 years is a long time.
Very long time.
So in this example, it couldn't be sold in whole or part. It didn't produce any liquidity or dividends for an extended period of time. I believe it was 5 or 8 years. So that would be a very long-term holding. but you didn't get to choose later if you were going to hold it or not. So if you decided to own that investment, even though it's a great investment, and then later you found out, well, you know what? I don't have access to that account or those funds for 5 years, 8 years, 17 years, that would be good to know. It may be the ideal investment, but so yes, sometimes the time that we want to own those investments makes sense for different time periods. And in some cases, once we've decided to add that to our account, we don't get a choice of when that leaves. So it's very important.
That's a very good point. I run into a very common scenario that I run into cases is that one party wants that liquidity, right? And the other party, they like their long-term investments. They don't need the cash. Maybe they're the upper income earner and the other one's the lower income earner or something like that. So again, when we're dealing with the brokerage account, I look at the statements and right away my eyes just glaze over because I, don't fully appreciate and understand what it is I'm looking at. But that's always one thing that I look at statements for is there liquidity in the brokerage account? But I have no idea of how easy it is or maybe how much it will cost to convert certain assets to cash.
So you brought up some good points. Liquidity, how much it costs. So when I would look at it, you look at, okay, so what does liquid mean? Sometimes liquid can mean it's available within 3 days. Sometimes liquidity or access to those funds means 30 days. Sometimes it means 12 months. Sometimes there's certain costs associated with selling or exchanging those investments. Depending on the type of investments, if something that I would call semi-liquid, let's say you have to own it for a year. If you access it prior to the year, sometimes there's a penalty from the fund company. It could be 1%, it could be 5%, it could be 8%. So that's an internal penalty that's there. And then when we talk about, well, then is it taxable if I remove it from my account and sell it? In a lot of cases, you're going to trigger both events. So maybe there's a penalty with liquidating prior than you agreed to, whether you knew about that agreement or not, or if you recall it. And then sometimes it's taxable. So you could have the example where liquidity is needed. There could be a 1 to 5% penalty. Well, I didn't really like that, but I needed the cash or the liquidity. And then, oh, by the way, it's a taxable event. Well, depending on your how you've structured your taxes and your income tax and your income and the rest of the account, you could see anywhere from, just off the top of my head, a 10% tax, 28% to 32%. We don't know until we ask those questions. So the example could be, I need $10,000 from this investment, but maybe there's a penalty, maybe taxes, and then maybe the net event is considerably less. Unfortunately, a lot of those answers come after the account is divided, because in a divorce, we kind of want to be finished and we kind of want to be done, and we don't want to talk to our spouse. Sometimes we don't want to talk to the people that are working on cases because we've been around them a little too much. But those conversations are important because, and I've mentioned before, the main reason I got involved with working on divorce cases is people were coming into the office after the fact with issues. Some of those issues could be easily resolved and some of them couldn't. But in almost every case, the person was saying, I didn't know that, or we didn't even spend the time thinking about that. And so divorce needs to be done on a timely basis, but it tends to get expensive afterwards. And it's when we need that money, and then it just creates other issues that sometimes can't be resolved or are difficult.
Does it also, can it increase, well, let me put it this way. take the scenario where you have a party who says, I don't trust anybody, including my own financial advisor. I want exactly what the other party's getting. So I want to take this complex brokerage account, it might be full of 1,000 different stocks, and say, divide each and every one of these 50-50. That sounds like a lot of work to me for somebody, the broker probably. But wouldn't it also equate to just multiple transactions that could result in brokerage fees that would be taken out of the account and ultimately basically destroy wealth?
Well, there could be fees associated with that. Sometimes you can divide those assets. Sometimes assets can only be divided in whole shares. So not everything is always in whole shares. The other thing that can happen is some of those investments can't be divided. So it sounds odd, but so you have to look at every line item differently. Now, the example you said is there's multiple pages of this statement of these investments that are there. It's not as easily done as you would think it is to just basically take a paper cutter and divide that account in half and divide those assets. It could be done, but sometimes it doesn't make sense for either party. Usually what tends to happen is that approach is rare because when you look at the cost associated with it, can you divide those assets and does it make sense for both parties? I think that's rare. Usually there's some version of that, but maybe in some simpler statements that could be possible. But in practice, once you've had a chance to explain the mechanics of what's there, usually both parties will agree, yeah, we don't want to do that once they've had a little more background. So, yeah, that's helpful.
Sounds like it's probably always worth the lecture of cutting off one's nose to spite their face.
I think that's exactly what happens.
We oftentimes see in family law,
Yes.
and that's one of these things we have to talk people in off the ledge and say, okay, yeah, you're going to hurt the other party, but you're going to hurt yourself.
It's going to
as
affect
much.
you too.
And
Yeah.
2 years from now, you'll probably regret the emotional involvement
I think
in
so.
the financial decision.
I think so. Well, I think this will be a good time to take a short break, and we'll be back in a moment. And when we come back, we'll talk about dividing assets during divorce when 50-50 is not equal. Thank you.
Securities and financial planning offered through LPL Financial, a registered investment advisor. Member FINRA SIPC. The opinions voiced in this show are for general information only and are not intended to provide specific advice or recommendations for any individual. To determine which investments may be appropriate for you, consult with your attorney, accountant, and financial advisor or tax advisor prior to investing.
We're back. This is Planning for Win, Financial Guidance in Life. I'm Kevin Pinkley. Thank you for joining us. We're going to continue with dividing assets during a divorce when 50-50 is not equal. Ernie, thank you for being here today.
Thanks again for having me, Kevin. It's been a very interesting conversation.
Well, we were talking about brokerage statements, and wanted to mention real quickly on brokerage statements what we don't usually spend hardly any time on when we look at the brokerage statement, and that's the line that says money market. Depending on your brokerage account, it may say cash equivalent. Usually we see that, we think cash, and we move on. In some cases, that's correct. In some cases, that account is what I would call something different than money market or cash equivalent. Often, when we look at large amounts of cash, whether it's through a business owner or someone has a larger amount of cash, maybe the firm that they're working with has said, you know what, our money market isn't paying a whole lot right now. That's just the way it is. That's the marketplace. And we can't get any return on that. It's like a fraction of a percent. And we've seen that for quite a long period of time now. Well, sometimes the firms will have an alternative. And when we look at it on the statement, it literally says money market or it says cash equivalent. What that really is, in some cases, is an alternative to money market and a cash equivalent, meaning the liquidity may not be there in certain situations. So someone has dollars in money market or cash equivalent. There's a lot of zeros there. And they think, well, I'll just pick up the phone and that's available and I can do with it what I choose to and pay bills and move cash around. Because as we know, during a divorce, liquidity or cash is important, right?
Yes.
Okay. It answers a lot of questions. Well, it hasn't really been in the news lately, but if we go back a number of years, 08 or 09, we were seeing a lot of this situation happening that I'm about to describe. And there's been small instances of that happening over the years, but not as much as was in 08 or 09. So people had large amounts in cash, and they needed to withdraw those amounts for whatever reason or transfer them. If you recall, painfully, 08 or 09 was a significant market decline.
Oh, yes.
Well, when clients were calling to access that line that said on their statement cash equivalent or maybe money market or something similar to that, their advisor or broker was having a very uncomfortable conversation with them to explain how it was different than cash or money market. And what was happening is that cash wasn't liquid. It wasn't liquid in 30 days. It wasn't liquid in 6 months. In that case, we were seeing 12 months or 18 months before those funds were available because it was not designed as cash as we would convey it on the street, if you will. So we had clients with, not we, but the public had assets they couldn't access that was titled as money market or cash equivalent. Very large companies were in the same situation. School districts were in this situation. There were school districts out there that didn't have access to their funds for 12 months. So there was a lot of conversations happening with, it's liquid but. So when we look at that statement, we need to spend a few minutes and ask, is it truly a cash account? Is it truly a money market account? Because in a lot of cases, it will be something else that's not as liquid.
Is this something that a layperson could spot?
No, because on the statement, now there might be an asterisk next to it, and on the 18th page of the statement, there might be a disclosure that, frankly, I can't read unless you put it under a magnifying glass. And it's probably something that was explained to them at the time, but maybe they forgot about it.
Yeah, 10 years ago, right?
Right. So what I'm saying is that when things get complicated and we're going through a divorce and maybe lots of things are being complicated and going on in the marketplace, those funds may not be liquid. So it happened to individuals. It happened to restaurant chains. And so it didn't matter how many zeros were there or how many attorneys they sent over to represent the client. The firms were going, well, the client agreed to it. We explained it. And it's just not liquid for a period of time.
I would imagine there's more than one pension fund that probably felt the pain of that as well.
I'm sure there was. So that doesn't happen every day. But so here's the example. Someone will say, here's my statement. It's pretty simple. Here's money market. And at the end of the conversation, I'll go, that's great. I just need to ask some more questions about money market from you, probably your advisor, and maybe the firm. And people are like, well, I don't really understand that, Kevin. It's cash. What do we need to talk about? And in a lot of cases, it's exactly what it represents. It's very liquid, and it can move out per a phone call. I have had quite a few surprised people go, what do you mean it's not available for 30 days? Or what do you mean it's not available if the market does this or interest rates does this? So those funds may not be accessible. And they wouldn't be accessible during a divorce. They wouldn't be accessible for regular needs of a couple or a business. So I usually ask for someone's patience during this part of it, that it's going to sound odd that I need to ask a few questions about your money market. But in most cases, once I explain that, people are like, oh, okay, well, that makes sense. And if they are in the situation where it's something that I thought it wasn't. They're very relieved, and sometimes they make adjustments, but those adjustments are before they need it. Okay. The other thing that I want to mention is certificates of deposits, CDs. Okay, they're pretty simple. Most people could explain those. If you purchase a CD today, there's usually a disclosure with it. It could be a 30-page disclosure. I've seen 52-page disclosures on CDs. Now, in some cases, those 52 pages are just boilerplate, and it's just basically protecting you and the firm. In some cases, when you look at maybe page 23 or 46, there's some stipulations in there on liquidity and pricing of that instrument, and that's news to people. So a number of years ago, we didn't have disclosures with CDs, and if they were only a line item or two. But it's very common to have a 30 or 50-page disclosure or somewhere in there with a CD. So
that's a lot of trees, by the way.
It is. The good thing is you can get those online sometimes. But so again, I would ask for patience when I'm asking about your CD, but it's news to some people that usually there's a disclosure attached to that CD, and in a lot of cases, what you think the CD is accurate, and the mechanics of it and the liquidity of it. But in some cases, there's a few sentences on there that could change the situation when you need to access that. And the first time I saw that, I said, well, I don't know what's in there, but there's a reason it's 52 pages, and we need to ask a few questions. So I just wanted to mention that quickly, that money market and cash equivalent is not always the same.
Sounds like something to keep an eye out for.
Yeah.
So here's another scenario that, again, it's fairly common in the family law practice, my practice anyway. Mm-hmm. We might not have parties that have these complex brokerage accounts, mm-hmm. Okay? A lot of parties, their assets are going to be limited to their house, mm-hmm. and to either one or two retirement accounts, oftentimes either a 401k or an IRA or both, okay? So again, we add things up, and we're saying, okay, we're going to be 50-50, so we just divide that retirement account 50-50, or maybe one party gets the 401k, one party gets the IRA. Mm-hmm. But still, IRAs can be infinitely complex within its own umbrella, mm-hmm. correct? And same with the 401k.
Correct.
So is this an area where a financial professional can go in and look at an IRA and say, okay, we can do better than just dividing this thing 50-50 to meet goals and interests?
I'm glad you brought that up, Ernie. I wanted to start with the 401k. Traditionally, 401ks are not something we pay a lot of attention to. It's provided by our company or maybe ourselves and to our employees. We put money in it, and over time it grows, but we don't really pay a lot of attention to it because we have other important things to do. When we start talking about moving IRAs, changing ownership of 401ks, dividing up 401ks, the first thing we need to do is look at the company plans because they're all different. So if someone works for a Fortune 100 company, a Fortune 500 company, or the company next door, or a smaller, what I would call mom and pop company that offers a 401k, the stipulations within that 401k are all different. Okay, there's different plans that are provided to each company. There's different benefits. There's different constraints that are there. So if you work for, look out your window. If you work for that company, their plan is going to be different than the one that's down the road. So you need to ask those questions because when it comes down to the details, we always ask for the plan documents. Okay, that's the key term, the plan documents. And in some cases, it's like, hey, this is very simple. There's nothing we need to be concerned about or address. And then in some cases, it's like, oh, okay, we need to talk about this and just make sure everybody understands. So we'll always ask for the plan documents because they're very different. And they change over time. And I wanted to mention something that The reason we ask for the plan documents is maybe there's a person at your company in HR or legal that works with the plan provider, your 401k provider, and maybe they're up to speed on that. Maybe they're not. Those plans change from time to time. So your plan from 2 years ago could be very different today, even if it's with the same company, okay? In particular, if it's with a different company. So we're going to ask for those plan documents, and if there's nothing to address, fine, but we've looked into it. So that's important. The IRAs are I would say are a little more involved, because that's something to some degree that you put together, that you had some thought in the investments that go in there. There may be some investments, whether you're aware of it or not, that you don't want to get rid of because maybe they're not available somewhere else, okay? Some investments, we would use the term close from time to time, that it seems odd, but maybe it's an investment we own, it's great. A lot of other people think it's great, but then that asset or that position receives so much money that they go, you know what, we have so much in this investment, we're not going to accept any more dollars. We're not going to accept any more ownership. And it's done for different reasons. Sometimes it gets so large that they can't buy quality investments anymore. They're literally so big that they can't invest their money. In some cases, they're a smaller company, let's say a mutual fund, and they want to be a little more nimble. Okay, they can't do that with a certain size, so they'll stop taking assets. And sometimes it's what they call a hard close, where they say, we're not accepting any new money, whether you own this account before or not, or if you own it now. So in some cases, you'll divide this asset or get rid of it completely and say, I'll just buy it later. And then you find out, well, I can't own it now. And you'll ask this investment or mutual fund company or whatever it might be, when might it be open? They might go, I don't know, we'll open it up in 6 months. They might say 6 years. So sometimes that's not a big consideration, and sometimes it is, especially, I mean, we become attached sometimes to these investments.
Oh, yes.
And there are ones that you don't want to walk away and exclude yourself from when those events happen. So that's one of the things to consider. Okay, I kind of started running with that, and but yeah, there are a lot of reasons why we need to look at IRAs even more so than 401ks, because a lot of times, not always, but with 401ks, we're liquidating those and just moving them to other people without a taxable event. I'll add, if it's done correctly. But in the IRAs, usually it's something that we're going to continue investment-wise in the future. And I mean, I'll use the example. I mean, some people plan to pass these investments on to other generations or other institutions when they're not here, because they're so attached to those for a lot of reasons. And you know, sometimes you can't get invited back to purchase that investment because they just are going to manage the existing clients, and they're not going to do that. I mean, there's other reasons, but that's one that I think we don't sometimes consider, that sometimes is very important.
So again, I'm soaking all this in, and it's just shoring up an opinion that I formed, a while ago, and it just keeps getting stronger. And that is, when you have investments, even simple investments, and you're contemplating a divorce, you really should bring in the advice of a financial professional. Do not rely upon your attorney. Probably you don't even rely upon your CPA to give you that kind of financial advice, to advise you of what you have, what your goals and interests are. You share that with them so that you can make a plan. And divorces very much require a plan. I mean, the title of the show, Planning for When, is just, it sums it up.
Right.
You have to make these plans, and it requires expertise. And again, just to underline this, an exclamation point, attorneys do what we do, and we're pretty good at it. But it's not our bailiwick. It's not our profession, most of us, to manage financial affairs, to advise financially on how to do things. Sure, we can sit here all day long and say 50-50, but 50-50 of what?
Right.
I also want to touch on something. We've had this conversation before, either on these shows or at other engagements. If anybody out there is contemplating a do-it-yourself divorce, be wary. Again, sit down with a financial planner. But if you have that IRA or that 401k and you think, well, we're just going to liquidate this and divide it 50-50, you've made a tremendous mistake.
Right.
You've made a tremendous mistake.
Well, how can I not end on that subject and that note? We wanted to thank you for joining us today at Planning for Win Financial Guidance in Life. Ernie, if the listeners want to reach out to you, how would they go about doing that?
Again, I'm with Currier and Martin. That's Currier and Martin, www.couriermartin.com. I can also be emailed at emartin@couriermartin.com, and you can call me at 281-890-7090, extension 103.
Thank you, Ernie. Well, thank you for listening for Planning for Win Financial Guidance in Life. I'm Kevin Pinkley. You can join us next month, the last Tuesday of the month at 1 p.m. You can check us out online at Lone Star Community Radio, and you can always reach me personally at 832-375-0900. Thank you.
Thanks.
Securities and financial planning offered through LPL Financial, a registered investment advisor. Member FINRA SIPC. The opinions voiced in this show are for general information only and are not intended to provide specific advice or recommendations for any individual. To determine which investments may be appropriate for you, consult with your attorney, accountant, and financial advisor or tax advisor prior to investing.